Daily cause list. Item number 1. Announcement of judgment.
View of the above. No case has been made out by the petitioner to interfere with the impugned order dated 9/8/2023. The criminal petition stand dismissed.
Obliged.
Oblige, Your Lordship. Please, Your Lordship. Lordship, I beg to mention item 6.
Item 6. Which is the other side? Yes.
Lordship, I'm praying for a week's time, Your Lordship, in this matter, Your Lordship.
We have no objection
You are appearing for?
for EPF ownership respondent.
That is that matter.
Lordship, will we have to come instruction whether
Provision of appeal is there. Why you are not disposing? A small issue involved here. The petitioner prays for grant of petitioner prays for adjournment. Counsel for the respondents have no objection. Clear, Lord. List of documents. Yes.
I'll oblige, Lordship.
May I please, Your Lordship? Item number 4 of the hearing list, Your Lordship. Mr. Conducting counsel, Mr. Sengupta, and Mr. Sengupta is not well, so I am praying for objection.
That is the request made on behalf of the state respondents. List after 2 weeks.
And one,
We finish it. Yes. Yes.
yes, Your Lordship, one more case also, number 10, item number 10 of the hearing list.
Yes.
This case,
The other side here.
other side, I have informed already.
No one is there.
She's
Madam, this matter, I think 10 may come up after 2 weeks, madam.
This matter is pending before
Before the
this
division.
division.
That is relating to that issue.
Question.
Yes, yes.
Okay. Just you can have it after 3 weeks. Maybe
Right,
then it will be
right,
better. On the request made by the joint request of the parties, list after 3 weeks. Yes.
Much obliged.
Well, item number 5. I'm praying for just 1 week time. my lord.
Yes. Who's the other side?
Item number
Whose case is?
this is
Oh, sorry.
Yes, madam.
No objection, Your Lordship.
There also at the request of the petitioner, list after 2.
1 week time.
1.
Deeply obliged.
Obliged, Your Lordship. May it please, Your Lordship. Your Lordship, I beg to mention item number 11, Your Lordship. The conducting counsel, Miss N.G. Shilla, is not available today, Your Lordship.
Andy Shulai.
I've informed.
Andy Shulai is behind you.
N.G. Shilla, Your Lordship.
Okay, I'm sorry. Yes.
And for the petitioner, my lord.
No objection.
No motion.
Also, this is also after 2 weeks at the request of the state respondents. Yes.
Obliged.
Obliged, Lordship. May it please, Your Lordship. Lordship, I beg to mention item number 13.
Item 15.
13, Your Lordship. Lordship, let the matter be come up after 2 weeks, Your Lordship.
Item?
13.
Yes, you are for the petitioner.
Petitioner, Your Lordship.
It come after 4 weeks, Your Lordship, because what happened that is a quashing of a POXO on the basis of settlement. Your Lord.
This also just request of the petitioner. List of, we'll have it after 3 weeks.
3 weeks, Lordship, yes.
After 3 weeks.
Obliged.
When that matter before division bench is coming?
Lordship, that is awaiting the outcome of the pending case before the Honorable
The
Supreme Court.
same thing was here, but then counsel was so impatient. So that is why this court had to refer. Anyway.
Obliged, Your Lordship.
May I please, Your Lordship. Lordship, with the consent of the other side, I beg to mention item number 9. There is some personal difficulty, my lord. This matter can be taken up towards the end of this week, subject to Your Lordship's convenience.
Oh yeah, what is the end of this week? You just say either 1 week, 2 weeks and all.
The next week, my lord.
Sadhus is not present.
We have informed them.
You have informed.
Yes, my lord.
Okay, number 9 also. Just say the request of the respondent distracted after a week.
After a week.
Yes.
Highly obliged.
Item number 2.
Yes.
May it please, Your Lordship. Lordship, we are filing in the course of the day, Your Lordship.
What?
That application for striking down the name of petitioner number 1, Your Lordship.
Okay, Mr. Karim. Learned counsel with the petitioner submits that an application for striking of the name of the petitioner number 1, the matter will be filed during the course of the day. In view of the submission, is this matter after?
Item number 7.
Yes, this is a criminal writ petition, my lord, against the finding of the Border Security Force Code. Here, my lord, the writ petitioner has been convicted for an offence under the civil offence under the BSF code, but otherwise an offence under section 376 IPC. Initially, an FIR was filed, subsequent to which investigation was carried on. Thereafter, charge sheet was filed. After charge sheet was filed, because the offence was committed within the premises of the BSF, within the compound of the BSF, under the provision of the BSF Act, my lord, they decided to try the matter themselves. My lord, after
Investigation by the state police, but then trial by the
well, what happens?
security force.
Initially, they do the investigation. Charge sheet is filed. Subsequent to which application is filed before the session court that they will conduct the investigation themselves once again, and they will conduct the trial. Because some amount of investigation is
FIR was before the state authority.
before the state authorities.
So they conducted the investigation.
Yes, my lord.
After the filing of the charge sheet,
My lord.
then they filed an application for taking over the.
Taking over the entire.
So then matter was taken.
Taken over, then what they do is they also do their investigation. They prepare a ROE, record of evidence, subsequent to which they conduct a trial, similar to a trial by a court.
So what happens? Say supposing after the charge sheet,
Lordship.
with the trial, yes, madam, sit down. You want to say something?
Your Lordship, the DAJ is on legs. Your Lordship will be coming.
He'll be coming. He said, okay, you sit down. Let him get in. This will take bit time.
So
Now,
My lord.
once the charge sheet is filed, when the subsequent trial is taken over,
my lord.
so what happens? That charge sheet is not looked into by the security force court.
No, my lord.
So
They
they prepare their fresh
do their ROE,
now ROE.
record of evidence. They collect
Record
evidence.
of the evidence.
My lord.
Now, is it based on that charge sheet or they do it independently?
They do it independently, my lord.
So the charge sheet cannot be looked into in the trial at the time.
But technically not, my lord, because once they take over their own
What is the
investigation,
position of law?
my lord, that is what happens,
This
my lord.
court, you have to see, this court has not even basic idea about those things. You have to
Absolute.
Tell us.
This is a little technical, my lord. Now, what happens here is that since they say that it's a civil offense, they call it a civil offense. They have their own code. They try it themselves, and thereafter they come to a finding.
That much this
So-
court understands.
So,
But then one is trial is taken over.
my lord.
It is that to be done by conducted by the security force court.
Yes,
Okay.
yes, my lord.
Now, the question of the court is that when a trial, basically which is charge-sheeted on the basis of a investigation of the state police,
My lord.
when it goes for trial before a security force court,
My lord.
as you say, there has to be a record of evidence.
My lord.
Now, once that record of evidence comes, does it mean that it comes as a substitute to that charge sheet?
Well, technically it should, my lord, because otherwise,
So whatever is there in the charge sheet, including the documents or the witnesses named therein,
not
they do
looked
they
into.
do not become
Not
the
looked
same.
into.
Now the record of inquiry, it means if it is conducted, definitely that means that is on independent evidence.
Yes, yes, my lord.
It is an independent investigation.
Yes, my lord.
So by the time that investigation is undertaken, there is a delay if you take into consideration the date of occurrence.
Absolutely, there is.
Is it not that those evidences will get erased by the lapse of time?
So, my lord, what happens here, my lord, is since they say that all offences cannot be taken up by the BSF security code, only those offences where, my lord, are committed within the premises or where the person was in duty. Now, this offence was committed within the premises, so they took it up. Moment they take it up, my lord, what they do is they start collecting their own evidence because all the witnesses are from within the premises.
There are simultaneously two investigations is on.
But in a way, it is, my lord, because
No, what has happened in this case? Just tell us.
in this case, what has happened?
It means when this matter was investigated by the state police, there was simultaneous investigation by the.
Not simultaneous, my lord.
That is what
After the charge sheet was filed, only after the charge sheet was filed, they make an application to take over the entire.
That is precisely this court is asking.
Yes, my lord.
Please appreciate it from that angle.
But I've understood what lordship is
Preparation
saying.
of charge sheet takes some time, be it 6 months,
It does.
or 3 months, and
It
all
does.
those
It
things.
does.
So, if the record of evidence is prepared after the submission of the charge sheet, that means there is a delay.
There is a delay.
If you say it is the record of, if you say the record of evidence is an outcome of investigating independent investigation, in such a case, that means they launch their investigation after charge sheet is filed.
Because, my lord, only after they take it over, only then they can start preparing this.
Then what value that investigation will carry?
My lord, there is not long. My lord, if that is the case, then my lord, it will help my client. But what I am saying, my lord, here.
No, it is not that this is a query by the court. It is not that the
But
court
I'll
is
also
telling-
have to look into it because
It is
this
not a
never.
finding of the court
This
and do
actually
not
never
misunderstand it
crossed
that
my.
It goes to your advantage.
This
Until
never
and
crossed
unless-
my mind, my lord. This actually never crossed my mind, my lord.
But then that is what the basis. You see, I do not know if you are to argue a case.
No,
on
but
the
Here, my lord, what they do technically, my lord, in whether it's the armed forces or the BSF, my lord, if the offence is committed within the premises or when the person is in duty, my lord, they do their own investigation and they do their own. They have their own set up their own court and they basically come to a certain finding,
So we do-
which
so we do not have to look into what is there in charge sheet.
well, except
What
for the
investigation
FIR,
of this.
except for the FIR, my lord, I don't think so. There is anything else that we need to look into. During their ROE, my lord, my primary case here, my lord, were two
So you
technicalities.
will not be raising any issue from the.
I will not,
basing
my
on
lord,
the
because
investigation
I
of
have prepared a specific paperwork where, my lord, my entire thing is on the basis of whatever transpired before the BSF court only.
So that is based on record of evidence.
Yes, my lord.
So
Record of
that is not
evidence?
reference to the state investigation.
No, my lord.
Now, whether the witnesses
My lord.
under the state investigating authority is cited as this thing, witness there.
Most of them, my lord, interestingly, what happened, my lord, when the ROE was recorded, one particular person of the BSF made it very clear that these two people were having an affair. Interestingly, my lord, that witness is dropped when the actual evidence is taken by the BSF court. My lord, that is one of my grounds. Apart from that, my lord, generally what happens, my lord, when I file a criminal writ petition before this court against the fighting of the BSF court, my lord, Lordship will not generally look into evidence. Lordship will only look into the. Sorry.
That one hasn't come. It's coming on. You go, you start that one. This may take some time. So, the moment he comes, send him.
Lordship will generally only look into whether the act they have followed the procedure to the T or not. But my lord, there are certain judgments of the Supreme Court which say, my lord, if there is no evidence at all, or if the evidence is very, very sketchy, there is nothing that prevents this honorable court from looking into the evidence as well. I say that, my lord, in this particular case, Lordship has to appreciate the evidence because I say there is no evidence at all. This is not a case of 376, my lord. Apparently, these people were having an affair. When they were caught, the entire case transpired into an offence under 376.
What is the evidence of the survivor?
Well, the survivor does not say that we are in a relationship, of course, my lord, but there is a delay. There is a delay in filing of the FIR.
To presume something which is not in the record.
Well, not to presume, my lord. I am saying, my lord, I will try to satisfy this court, well, to make this court look into that particular aspect of the matter as
That
well.
is your job here, so that you will be doing.
Another-
say also that we know.
Another technical aspect here, my lord, is that this thing has also been decided by the division bench of this honorable court. Here, my lord, once the evidence is recorded, first there is something called a pre-confirmation of the finding. After the pre-confirmation, my lord, which is akin to a appeal filed by, suppose a person when a person is, my lord, thrown out from government service, my lord, there is something called a provision for statutory appeal. Suppose I am terminated from government service, I am given an opportunity to file a statutory appeal. Similar to that, my lord, since the finding are against me, I have also been terminated from service. So I have given an opportunity under the BSF Act to file an appeal post confirmation. Now, my lord, that post confirmation has to be decided by, my lord, the appointing authority, the highest appointing authority. But here, my lord, in this case, it has been signed by the law officer on his
Your
behalf.
conviction also.
I'm sorry, my lord.
It is in relation to your conviction on law or from
Both, my lord, conviction as well as because the conviction ultimately culminated into my lord, losing my job. So, my lord, this particular aspect was decided by the division bench. My lord, the division bench said that it is absolutely wrong. The post confirmation finding can never be signed by the law officer on behalf of the appointing authority. My lord, in that regard, there is a particular judgment of the division bench as well. So, my lord, I say, my lord, when this kind of BSF court conducts takes over takes over the particular, decides to try the particular offence themselves, my lord, they are supposed to follow every single regulation of the BSF Act to the T. Now, my lord, this most important aspect is, my lord, my right to file an appeal, a statutory appeal before the appointing authority for post confirmation saying that, my lord, I was not given a fair trial should have been decided by the highest officer, not by the law officer, my lord. This is one of the grounds which I have raised. And, my lord, also, In this regard, my lord, if lordship, I'll just
These are mostly technical pleas, not basically on merits of the
my lord,
facts of the case.
generally, my lord, generally, if there was certain amount of evidence in in this particular case, then my lord, I would not even have opened my.
Can you give in short what is your point, sir? Then
So, my lord, what?
Because
My lord,
this court will have to go to the basics. So
absolutely, my lord. There are so many things. Well, what I was suggesting, my lord, here is, lordship, if lordship will allow me, I've also spoken to my senior. This person was convicted on the 10th of May 2021. He was given 7 years punishment. My lord, 3 years he has been inside because even the post confirmation took almost a year's time. So, my lord, I have also filed a miscellaneous application for suspension of sentence. Now, my lord, if that can be considered, my lord, because this will take some time.
We are in the final hearing. Why should we have?
Well, because, my lord, there are so many technical aspects which have to be looked into.
See, Mr. Gautam,
My lord,
if you have to pass an order in your interim application also, we have to refer to the matters.
absolutely, my
There
lord.
is no other option.
Absolutely.
So why to undertake double exercise?
The
Since we
only-
have reached the final
The,
stage
the
of hearing,
only
let us do it.
the only argument here, my lord, is because, my lord, there are certain judgments of the Supreme Court also. My lord, if a person has almost completed half of the sentence, otherwise, then, my lord, the court can take a lenient view and suspend the sentence or grant
Here,
bail.
we are on different footings. We are ready for hearing.
So, my lord, in that,
These proposition is followed where appeal cannot be heard immediately. Here it is
well,
not.
this
there.
has actually taken some time as well, my lord. This was filed almost a couple of years back. Learned whether sir is ready to do for the argument.
But then, if you want, we can finish this matter. Only thing is that you have to be very specific to the point and all. If you are,
My lord, but there are a lot of evidence which need to be read, my lord, and a lot of technicalities. What I can do, my lord, if I will give a short gist of my argument in writing, pointing out the various aspects of law which I want to under the BSF Act. Then thereafter, my lord, on that particular day, my lord, if the matter can be taken up, it may be taken up. Otherwise, my lord, allow me to
we can do
also
it tomorrow, day after tomorrow, any day. But there
allow
you
me
are ready, we can.
allow me to press for the suspension of sentence also, my lord. I will try to satisfy you on that regard.
No,
also.
see, this you take it easy. This court will not take this exercise today. Because this will be, in any case, this will be, we'll have to.
No, on the aspect of, my lord, completing a certain
It should
amount
not
of
be something
time.
like that. You see, like you get in some interim order now, and thereafter you see matter remains pending. We are in the stage of filing. You see, like you will have ample opportunity if you want to argue for 2 days. We are ready for that. There is no problem in it.
No, my lord, my lord, lordship has said that if lordship has to pass an interim order, lordship has to pass on merit. Well, what I am saying, my lord, I am saying that, my lord, not on merit. If a person is convicted and if he has, my lord, served a certain period of time, in that case, my lord, I was only on that line.
See, that situation when it comes, what you are saying, with this court is aware of the proposition of law with the apex court says, where a person serves almost half of his sentence.
Yes, my lord.
The appeal cannot be taken up for final disposal. Here it is not the thing. This appeal is ready for final disposal.
Then, my lord, I'll
So
do.
that proposition will not apply in your case.
Then I'll do one thing, my lord. This particular, these facets of the BSF Court Act, my lord, whatever I'm trying to rely upon, I'll make a short gist.
That will greatly help this court. You
My
see,
lord.
especially the technical piece. If you can note it down, you do not have to make it elaborate.
No, I will just
Give
make a
the-
gist.
like a bullet points. That this is the law, this has been not followed. This is the okay. The law officer is not the concerned authority.
Yes,
You can
sir.
give a finding on that. He cannot sign it. Yes.
Under which
That is-
provision of
there
the
is-
Act?
Then number 2, number 3. Then it will become very easy. And that way, Dr. Mojika also will be prepared to answer. Any day.
Next week, then, my lord. You can have it on Monday next week, my lord.
Not think that you will have it after a week. Just another request. You can give it a bullet point in advance.
Yeah, I'll give it.
After a week. Please you give it.
Yes, my
The
lord.
interesting thing, this will be an opportunity to learn for the court.
My lord. If for me also, it's the first time I'm arguing a criminal lit petition against the finding of a BSF court, my lord.
You all are able,
Martial
yes, so
is-
definitely there will be a lot of things to know from you. Yes.
Much obliged.
Item number 8.
Yes.
This matter was heard on the
That
last.
311 matter.
My lord,
No reason was assigned.
my lord.
Yes. The issue was, or rather the question which this court had put to you was with regard to this, is there any difference between examination of a
The
person?
fresh witness
Yes.
and
Yes.
in
Is
that
there any difference of, see, like, so far as the grounds for consideration of application under 311 is concerned, is there any difference of proposition of law for considering the merit of the petition under 311 if it concerns the summoning of a fresh witness or summoning of witness who
has
for
already been
examination.
examined.
Is there any difference?
My lord, in my humble submission,
yes.
there is a difference. Only
No, but then are you saying it on the basis of some proposition?
no,
of
my
law?
lord, no, my lord. I'm on the process of doing some research, my lord. I need 1 week time, my lord, in this matter.
That is okay. You can take time. There is no problem.
My lord.
The court will grant you time. But then, is there anything? This court has not come across any such decision. Probably, Mr. Guru
lord.
also. I do not know. I don't think like you. Like so far as the proposition of law with regard to calling of a fresh witness and another a witness for the examination. Whether is there any difference of applying, whether the same yardstick will apply while considering the merits of application under 311, if it is in relation to fresh witness or a witness who has already been.
My lord, my respectful submission would be on both the scenario, my lord. The act itself is very clear on that, my lord. But if I get the query of this honorable court, since my learned
But
friend
then
is
Act doesn't say that what should be the prime and foremost consideration for like deciding those.
my lord, in that case, my lord,
Some idea, of
yes.
course, we can gather by reading many judgments of
My
the
lord.
law. Okay. But then I don't think there is.
In that case, my lord, since my
Anyway,
friend
since
is
he's
taking,
praying
yeah.
for a week's time,
So,
let us see,
my
and
lord,
if not, then issue here is not very big issue,
My
so
lord.
we can decide it anytime.
My
Just see. That's why it's also. This also just say after a week on the request to the. You do not have much to say. You
My
said that there you cannot beyond what the
My
record
Is
says.
there in
my
the
lord,
That is what.
my,
Two reasons this court remembers that the petition doesn't say anything,
my lord.
and the reasons given by the trial court is the confessional statement of the accused
accused and the
and 161
161?
state.
Deeply obliged, ma'am.
Item number 12.
Yes.
Lordship, in this matter, settlement, there's an agreement for settlement has been signed between the parties, petitioner and the private respondent. Your Lordship, I'm praying that this matter may come up after a week. We'll file
You are
an
seeking
affidavit.
quashing
Your
on the
Lordship.
basis of a settlement. And what is the crime involved?
Your Lordship, they have filed an FIR under Section 500 of IPC, defamation, which is not.
Defamation.
Your Lordship,
Defamation is not compoundable.
not.
Yes, what is your thing? State. You're opposing this application or? Yeah, I'm hearing Vice Mr. Sengupta. He's not here. You're not holding the file with you, record with you.
Your Lordship will file an affidavit bringing on record the settlement agreement between.
Okay, Washa, the settlement is not already on record.
No, Your Lordship, we just
Then
signed
this
it,
petition is based on what? This is on merits.
merits, Your Lordship.
Now, if you bring the settlement,
Lordship.
now would it mean that this petition would stand amended? This is a proceeding under criminal law. The provision of amendment
Your Lordship.
is unknown to criminal proceeding. Now, if you bring it on those also, which way it will have a bearing on the merits of the thing which you have already raised here. Will it not mean that it would amount to incorporating some fresh ground to your petition?
No, Your Lordship, once the settlement is before the placed before the court, Your Lordship, the matter may be closed since the settlement is.
No, then it will.
once-
Your settlement would become the basis for consideration,
Lordship.
isn't it? Once settlement becomes the basis for consideration.
I'm sorry, my lord, I was in the other court. My lord, what has happened here, my lord? They think they've come to a settlement. My lord, we'll file an affidavit to bring that on record. I've just been informed.
You
in
know,
the
what this settlement will have what bearing it will have in this 482 application? Will it mean this
It can be
petition will
withdrawn
stand-
also otherwise, my lord.
Will this mean this petition will stand amended?
No, my lord.
Or you
Technically,
can
my
say
lord,
that 482 court can do whatever it wants.
no, my lord. What can happen that my lord is they can withdraw the case otherwise.
That is
Because there's
what is
no
the
cause of
main
action.
thing. And then you file fresh application, or if you have a compromise, then matter ends there. Where
You can bring it on record, my lord, because I've just been
no, bringing on
instructed.
record, would it? Can we even if you? These are technical questions. We do not know. You may sometimes think that this court thinking is hyper technical, but then the problem is that in 482, it doesn't mean that you see like jurisdiction is unlimited. It is not
sparingly used.
Yes. So in 482 says, supposing if any fresh plea is brought and that plea becomes the main plea, replaces those earlier pleas which are existing, can it be considered, or it has to come by a fresh petition?
Well, under 482, my lord, of course, my lord, I may not be correct also, my lord. But 482 basically, my lord, for the ends of justice, my lord, the court can, my lord.
So you want to say that for ends of justice, there is no boundary for us.
My lord, the interesting power under 482 is, my lord, it has to be sparingly used, but my lord, it has not been defined. It can be stretched if the court finds that injustice has been done, there has been an abuse of the process of court, and if the court wants to do it for the ends of justice. But of course, my lord, the power has to be used sparingly, not in every single
Since
case.
you are emphasizing on that ends of justice, does it mean the ends of justice means there is no limitation?
No, my lord.
See, if law has some prescribed procedure for certain things, Code 82 cannot substitute that.
Absolutely, my lord.
That cannot. That is what is to be seen.
My understanding, my lord, the reason why 482 is there is, my lord, because everything has not been covered by the court.
See, 482 is not at all unfettered jurisdiction. You cannot say unfettered.
Not unfettered, my lord, but for case to case wise basis, my lord, the court feels, my lord, if in fact, my lord, even after conviction also 482 can be exercised. Normally, even if the revision lies also 482 can be exercised.
Normally, say like in cases where, especially the cases where the allegation is not of that heinous nature, and normally even parties compromise the court should give.
Yes.
But then definitely there is a manner of doing that.
In those cases, my lord, of course, matrimonial disputes or other disputes, small disputes, if parties have compromised,
Because
matters
sometimes
not
you see
compounded.
unregulated exercise of power results in many.
For example, my lord, if the offence is compoundable, then the court will not exercise powers under 482. They have to go back.
Nobody will come here also. Why should they be?
Some people like coming to the High Court, my lord.
Especially before this court.
I love coming to this court, my lord.
Okay, the council, learned council hearing for the parties. Sorry, the petitioner and the private respondent. Counsel for the petitioner and the private respondent submit that the parties have already arrived.
My lord, yes.
The parties have arrived into a settlement in the matter and would like to bring into the records of this court the deed of settlement prepared pursuant to the agreement arrived at by the parties. We'll hear the submission. This matter after 2 weeks. After 2 weeks? 2 weeks will be 2 weeks. Nothing more.